How much can you depend on what the media tells you about the trial of a case? Can you judge guilt or innocence? We'll talk about media in the courtroom right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
Do you watch trials on television, read about them in the papers? Can you trust what you see and hear? My guests are attorneys Elliot Hicks and Martin Sheehan. Elliot, Marty, I feel like I'm at home when you fellas are here.
I'm glad.
You're both trial lawyers, or have been over the years. How does the media influence trials?
Well, it's a tough question. It's hard to know exactly how much the media has affected your case before you go into the courtroom. The important thing there is to try to figure out, has the media done any damage to your case? If the media has helped your case, how do you play upon that? And how do you avoid the preconceived notions that people come into the courtroom with?
I thought that we were supposed to have a trial, though, that was objective, without bias. Jurors were supposed to be, well, in modern parlance, clueless. Don't mean that in a derogatory way, but they're not supposed to have any clues about the case when they sit in the jury.
Well, Dan, we're going for a system where jurors don't have a preconceived bias about a case. And the difficulty is that, particularly in the criminal setting, defendants typically, defendants with good lawyers, don't make any statements to the media prior to the trial. There's an accusation out there that's been publicized to some extent by the prosecutor. The charge hangs in the air as a doom and gloom situation. And so there is some anticipation about a final resolution, and that waiting period sometimes in a criminal case is largely perceived, I think, to be negative towards a criminal defendant.
But does the fact that a defendant in a case, in a criminal case, makes comments or not have anything to do with what the media coverage is going to be of the case?
Well, I don't do a lot of criminal work now. I don't do any criminal work now, but I have. And with all of the things that happen before or as the charge is being brought, with the newspaper coverage, with the perp walk, as they say, where they book the person and then walk them over to the or walk them over to the magistrate to be arraigned. All of those things really make a case that the defendant may need to say something, or the attorney for the defendant may need to say something to try to counter all of that publicity that may affect the case.
Let's talk about, you alluded to the perp walk. What is the word perp, I guess, stands for perpetrator?
That's what I understand.
Where does this come from? Why do we have this?
Well, a little bit the media wants to get the jump on a case. So we might sometimes know there's been a crime, a dead body's been discovered. And so there's the first clue really for the media that we're on the road to a solution is that someone's been arrested. The media likes to get that news out there, and so they'll try and get a picture. Very often that picture is going to be of a criminal defendant in handcuffs. If they've gotten the right person, well, that's not that big a problem, but if they've gotten the wrong person, boy, undoing that can sort of be a problem.
I want to read something. This comes from the May 30th, 2011 issue of The New Yorker. And they're talking about the Dominque Strauss-Kahn case. If you remember that one, he was an official with the International Monetary Fund, I think, was the head of the International Monetary Fund, was a candidate for the presidency of France, and he was accused of rape in New York City. And there was a lot of court proceedings going on. That case was ultimately dismissed, but it received great media coverage. The New Yorker said the French were appalled to see video of Strauss-Kahn's perp walk in Harlem and photographs of his arraignment. It is illegal to take and display such photographs in France, where the protection of reputation is considered an extension of the presumption of innocence, just as it is forbidden under the Geneva Convention to parade or humiliate prisoners of war. They perceive it as a human rights violation.
The fact is, I do too. To put a person in handcuffs and lead them around like that, to put them in a humiliating situation, certainly hurts the perception of that person's innocence when they come to trial. I think we should a little more jealously guard the rights of the defendant when it comes to the things that happen before trial. The things that we do in trial, we've done a pretty good job of that, but I think that what happens before trial, we have some problems with. And to lead a person who, I think they were concerned, I remember reading the news accounts of this one, and they were concerned that he was disheveled, that he wasn't freshly shaven, he didn't have a tie on as he usually did, and so...
He didn't look like the head of the IMF.
Exactly. He didn't look like himself. He didn't look like the powerful man that he was, which, may be a problem to some. But it is a problem that we make a person look awfully guilty before we've had any judicial determination of that.
Well, I agree, and having people parade around in orange is sort of a problem as well. Difficulty
the
is
orange jumpsuits.
The orange
that they wear
jumpsuits
here
in West Virginia, absolutely. It says WV, I think, somewhere, but
not the one on the football field.
Not the football one, no. But the difficulty really is that the First Amendment issue, and that's what the media is going to work on, and say that we have a right to cover it. And I'm not going to deny that it's news, Elliot. But yeah, it would be nice if my client could shave, or comb his hair, or appear in civilian dress. I mean, we do try to guard that in the courtroom, but there are a lot of pictures that will get out that are somewhat inconvenient. During a trial, when your client's wearing civilian clothing, as the Supreme Court said it has to be the case, they'll get out an old file clip and run it on TV of your client in orange.
Yeah, the law is, we talk about the Supreme Court, in this case we mean the United States Supreme Court, that the defendant in a criminal case is allowed to come to court dressed as a human being. The defendant, it's pretty much up to the defendant what he wears as long as it's available to him or her. But the orange jumpsuit that you're photographed in all the way up to trial kind of tags you as a criminal.
Well, it makes for an exciting visual for the news media, for the television media, to see the person as they go in handcuffs from one place to the next. Certainly the police like to arrest a person when they're not expecting it. So what that means is when you're sitting on your sofa with, I guess a bag of Doritos or whatever, and they come and knock on your door, or when you're even asleep and they want to come in when you're not prepared for it, so that there will be less chance of any altercation.
They try to catch you in a state of confusion.
Right, and that state of confusion.
5 o'clock in the morning.
Right.
It's the ideal time to make arrests for people who've been out all night. That's when it's done.
And that state of confusion often results in you looking like your hair's not combed, you have on something that you wouldn't be inclined to wear outside, and it presents a problem.
We protect the identity of the victim in sex crimes cases. In some cases, when there are cameras in the courtroom, we protect the identity of the jurors. Are they more important than the defendant who is presumed innocent?
Well, Dan, I'm going to speak up for jurors. I'm in favor of letting a juror who's gotten a summons to come to court and has been selected largely against their will to do a public service. I don't have a problem with that.
I agree.
I'm not so concerned if we try to blank out child witnesses. I am concerned that adults are not often, adult witnesses are getting more favorable treatment. Part of the problem there is that everyone's credibility is being judged. And if you don't really see a trial, if you don't see how a person's communicating, if you get this secondhand, there's some distortion in people's ability to observe what's happening in a courtroom. I mean, the difficulty is they don't have enough time to put every trial on TV and for everybody to watch it 24 hours, 7 days a week. But and so there is some editing. And when you edit, you don't always get what you want.
One of the concerns that I've discussed with people is that you have, when a person is arrested, when a person's name is splashed across the media, you have the opportunity to judge that person's credibility, and all of the people come out of the woodwork who've had various experiences with the accused. When we need to hear a little bit more sometimes about the accuser, because sometimes they have some stories that need to come out in order to balance the information that's available. If those people came out of the woodwork as well, then we might have a little more balance to understand exactly what the story is. But that becomes a problem. I understand that witnesses are intimidated by publicity, and that sometimes we won't have the level of reporting that we need to have to try to keep crime to a minimum.
Well, I would have no problem with protecting the identity of jurors or protecting the identity of the accuser, for that matter. We can objectively describe the accuser. We can objectively describe the jurors. One is an engineer, one is a housewife, one is a farmer, or whatever.
Maybe, Dan, but the case that I think scares most defense lawyers is the Duke Lacrosse case. There was an accusation made. Fortunately, I don't remember the names of the defendants. I just remember that
they're out there.
Well, yeah, but they're the Duke Lacrosse players. There's a little anonymity there. And it turns out that was an accusation that,
not well-founded.
Yeah, that's a great way to say that. Thank you.
We're talking about media in the courtroom. My guests are attorneys Elliot Hicks and Martin Sheehan. I'm Dan Ringer, and this is The Law Works. The Duke Lacrosse case, if you recall, the Duke Lacrosse team was accused en masse of rape and various other activities at basically a team party. And once we got beneath the surface of that, or once the correct officials got beneath the surface, they found that it was not a substantial, not a sustainable accusation, and the case was dismissed. But not until every member of that team who was present in that location at that time was essentially tarred. They had been thrown out of the university. The team had been disbanded. So if we're going to protect the identity of jurors, of accusers, in some cases of witnesses, why not protect the identity of the defendant? Why can't we just report that a man, a woman, a dog, whatever the defendant is, was accused or was arrested? In this particular case, there's going to be a trial on October 7th or whatever date it is.
Dan, the police, often county sheriff, some elected official has been tasked with the job of solving a crime. You get a dead body from the river, you find a situation, there's been a robbery, there's been a break-in. People are genuinely concerned about their safety, about the safety of their property. Those are solving crime quickly is part of how we judge whether elected officials are doing their job.
But can't the elected officials say we have a suspect in custody?
Well, do you ever think an elected official would ever do that? Well, of course not, because the way they get reelected is by appearing to clean up the world, clean up their neighborhood. So they're not going to comply with that. Besides that, with all the cell phone cameras and things that we have, it's almost impossible to keep that under wraps. So effectively, we are not going to be able to do that.
If let's abandon then this facade of privacy and of presumption of innocence, and just say Elliot Hicks was arrested for whatever the heinous crime of the day is, and Marty Sheehan is his accuser. And let the public, let the media have at it then. We know who both of them are.
So be it.
So be it. I'll live with that. That's the First Amendment rules. That's the First Amendment life we live in. And the media has sort of self-imposed its rule on victims. And largely that's because being a victim of some crime has somehow been deemed a problem. I mean, a woman who makes an accusation of rape sometimes feel like she's less valuable because she's been raped. That's a sort of ridiculous social...
And she feels like she's on trial.
Yeah, it's ridiculous, but it's a ridiculous social viewpoint to think that you're worthless if that's the kind of thing that's happened to you. It's very often not your fault.
Yeah, that's the reason we call them victims, because it's not their fault. But we just can't, there's no way to believe that anybody would really keep all these identities secret. So it really needs to be out there so that it can be judged, so that they can be judged equally. I'm not necessarily saying in sexual assault cases specifically, but it is something that we have to wrestle with as a society.
Well, we have no problem saying the First Intergalactic Bank says it was robbed this afternoon. Right? They're a victim too. But sex crimes are different.
Right.
We don't have the answer to that. Maybe the media could help us with backing off a little bit. Let's talk about another case where the defendant ultimately ended up being found not guilty, not innocent. A jury does not find that anybody is innocent. They find that they're not guilty. But she, in this case, was pilloried, was cursed, damned, and will be forever followed. And I take this from Time magazine. During the trial, the headline in an article in Time magazine said, "Few doubt that Casey Anthony was involved in her child's death." Wasn't that what the trial was for? And during the trial, Time magazine runs a headline that says, well, we all know it, she was involved. The question is, what was her involvement? And honestly, I don't know that we did all know that.
Well, when we protect the identity of minors, when we protect the identity of people who've been victims of sexual assault, a lot of that is self-imposed by the media. They decide they won't do it. In a lot of noteworthy cases, and I guess somebody decided that the Casey Anthony trial was a noteworthy one, the media will not self-censor and will not try to keep a lid on some of its presuppositions on guilt or innocence.
The horrifying thing that I saw in the Casey Anthony trial was not that the media was covering it, but that the media commentators who were damning her during the trial, pronouncing her defense attorney to be essentially an idiot. He didn't turn out to be such a bad defense attorney in the final analysis. Were lawyers.
Well, you would think they would know better. The difficulty is that most criminal trials are not really about guilt or innocence. They're really about, have the police eliminated all the other suspects? Did they follow the leads reasonably? The Casey Anthony case is problematic. I think I'm the only person in America who didn't follow it until it was over. But in looking back, the coroner in the case said that he thought there was a homicide, but he couldn't say what the means of death were. That doesn't sound like the best case in the world. I'm a little surprised that people who had some inkling that that was true, which they should have known from the discovery or that kind of thing, would have sort of jumped to conclusions about guilt in a case that was that marginal. I mean, I've tried cases, and very often what a defense lawyer wants to do is to say, the police haven't exhausted all of the options. They didn't run down all the leads. I tried a case where I attempted to suggest that there was an open explanation fairly recently. And that case, my open explanation was a little difficult to get there, but we worked on that. I thought we presented a pretty good evidence of reasonable doubt in the case. So it's not so much about have they got you, but are you sure we've got you?
We're talking about media in the courtroom. My guests are attorneys Elliot Hicks and Martin Sheehan. I'm Dan Ringer, and this is The Law Works. I have probably an advantage over either of you. I work for myself, my office is mine, and I have a TV set in it connected to cable. So I watched pretty much all of the Casey
Anthony. You have too much time on your hands.
I watched pretty much all of the Casey Anthony trial that was displayed on the TV screen. It was on headline news. And I had several what I will call heart-wrenching moments, not heart-wrenching moments, because I watched the way the trial was described. I want to give you this example because it was like something out of Alice in Wonderland. There was a discussion in the courtroom. Jose Baez, the defense attorney, was making his closing argument. He saw out of the corner of his eye something at the prosecution table. He glanced over, and what he believed he saw was the prosecutor laughing or snickering into his hand. Well, he was upset by this, so he referred to the prosecutor in front of the jury as laughing boy over here. Well, that's designed to elicit a response from the prosecutor, and sure enough, somebody at prosecutor's table jumped up and said, "Objection." And the judge looked at them and said, "Come here." Brought them both up for what is called a bench conference, and undoubtedly, because we've all been there, I believe this is what happened. It was not on TV. What I believe happened during that bench conference was the judge looked at the defense attorney and said, "Why did you say that?" And the defense attorney said, "Because he was laughing into his hand and distracting the jury." And the judge looked at the prosecutor and said, "Were you doing that?" And the prosecutor most likely said, "Yes, I'm sorry, I shouldn't do that." And the judge would have said, "Okay, don't do that anymore." And then he would have turned to the defense attorney and said, "And the next time you want to comment on something like that, you bring it up here, you don't tell the jury." Are we in agreement that that's a likely scenario?
That is.
Very much so.
Break to the legal commentator who was watching the trial. It was Nancy Grace, who is a lawyer, or was, and her comment was, "They almost came to blows there in the courtroom. They were yelling and screaming at each other." No, I watched it.
Right.
That's not what happened.
Well,
Why describe something that erroneously?
all of us who have any of us who've had a trial that was covered by the media have the experience of coming home and seeing that coverage and wondering if we were at the same place as the commentator. And that's what happened. That's what
Yes.
happened here. I mean, here we have somebody who, when you talked about legal commentators who should know better than to make prejudicial statements about trials. But the thing is, I mean, let's look at them. They're paid now by the media to try to sensationalize these trials so that they get ratings. I mean, Nancy Grace that you mentioned.
They're selling advertising. And if you have a trial that's boring, and let's face it, most trials are boring.
Right.
Long stretches of boredom at the very least.
Yeah, and if you don't think a trial's boring, just watch some Congress. That'll be equally boring.
about the same.
But anyway, it's they need to make that more exciting. And the truth is, they don't have any expectation of how it's going to happen in the future, exactly what the next witness will say, exactly how the cross-examination will come down. They do have the benefit of hindsight. It's like, well, something awful happened. Tune in now, keep watching the show, and that's what it's about. It's not really about trying to report the mechanics of the modern justice system. The
But
emphasis
wait. They're called reporters.
No, that's just because they are media hounds who've taken over a reporter's job. They report something. I mean, Nancy Grace, for instance, is one who really made it her sworn purpose to try to get justice for Kaylee even now. I joined Marty in not following that trial very closely, and I said that I only wanted to look at the case I was surprised at the verdict because I'd heard so much about it, and certainly from so many people it was a foregone conclusion that there would be a conviction.
Who watched at least some parts of the trial had really serious doubts about what the verdict was going to be.
And that's it, because and that's what we know, and that's what we can go and spread the word on, is that, you know, it takes evidence to convict people. This jury was really particularly worthy of some admiration because there was so much controversy, so much coverage of this, and the coverage was all slanted toward guilt. And so for them to sift through that and actually find that there was not enough evidence to convict was a pretty courageous thing, particularly in light of the things that happened during the Simpson case, where these people are then castigated as idiots and fools and all that sort of thing. And of course that happened in this case as well.
Well, what happens when you have coverage, I'll call it coverage like that of a trial, is that the folks at home see it, they form opinions as to guilt or not guilt. Again, nobody's innocent. It's either you're guilty or you're not guilty. And then when the verdict comes back contrary to their expectations, they are appalled, they're outraged, and they too start screaming for justice for Kaylee.
Right. I wrote an article after the Simpson case that talked about all these people who had said that they had watched the Simpson trial. Well, if you had a job, you did not watch the Simpson trial. Well, then, notwithstanding. and even now that you can, a person, I mean, I guess ordinary people could bring their own laptops and watch the thing on the streaming video and all that, but people don't do that. Not if they're if they're legitimately getting paid to do something, they don't do that. Yet people thought they had, I saw the whole trial. Well, you didn't see the whole trial, and you don't know what happened, and yet you're forming an opinion about how that evidence came in and all of that. And that makes for a real problem for anybody who does face the justice system and come out on the positive side of it.
Marty, what do you say when somebody says, do you think O.J. or Casey Anthony did it?
Well, the people asked me about the Casey Anthony thing, and I said, not following it, I have no opinion. And that sounds like you're not involved in modern life. I mean, the lead up on the O.J. case was certainly very different. I've talked to people about the case later, and why it seemed that the case came out the way it did. That's a fairly complicated case.
Mm-hmm. What is your reaction when somebody asks you about did he or she do it?
I say that I wasn't there, and it's the same thing. There's really no other answer, but I wasn't there, and I don't know. Now, when you talk about whether they really did it, I mean, certainly I may have a little bit of an opinion, but it really doesn't matter.
Marty Sheehan, Elliot Hicks, thank you, gentlemen, for being with us. There is more to the trial of a case than what you see on television. You are warned. Thank you for being with us. I'm Dan Ringer on behalf of the LawWorks. Good night. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us email at thelawworks@comcast.net or visit us on Facebook.
The LawWorks is produced in cooperation with the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
From West Virginia Public Broadcasting.